rare and balanced view on politics in today's world. Based on facts, born of rationality, common sense, and logic, providing context on today's events. This is American Perspective with Rick Thomas.
Hello, everyone, and welcome to American Perspective. Yes, it is episode 600. I just realized that as I was getting ready for the show. Oh, wait, what's that? Oh, you're wondering about the little friend that I have over here on the image. I haven't seen Buddy pop in just yet. So let me go ahead and explain. Folks, last night I made a big error. I made a big boo-boo. And that was I neglected to grab Buddy's Pet of the Week for last night's Pet of the Week. And because of that error, I decided that what I would do is I would go ahead and put last night's Pet of the Week, and I'll explain about who this is. Last night's Pet of the Week on the screen with me for the entire episode as a way of an apology to my longtime Whiskey Warrior P1, Buddy Weiser, and his friend, yes, his friend, Hank, because this is Chloe. Chloe is Hank's dog. And Hank says that she is a good watchdog and a companion for him. And Buddy, of course, told Hank that he would get Chloe onto the show. And so for that, what I'm going to do is I'm like I said, I'm putting her up there. So every time I go to this scene, she will be with me, hanging out on my shoulder, being the good watchdog that she always is for this. Now, Buddy says that Hank is a good person. So he is 100% sure. There's no question here. 100% sure that Chloe is a great dog. So Chloe is going to hang out with me every time I go to this scene. Okay. Unfortunately, we don't fit together in the small pictures, but there she is. So Chloe is going to be with me the entire show, with the exception of when I swap over and show you guys stuff. So there you go. That is the answer. That is the apology, like I said, for me basically screwing up. And so hopefully Buddy and Chloe and Hank especially will be appreciative of that as my apology for the thing. So anyway, it is totally my mistake. I mean, I totally spaced it, and yeah. So Chloe's gonna hang out and she's gonna help me pass out the information that I'm working on. All right. Let's go ahead and get things kicked off. Nana of JJS is up for tonight's Pledge of Allegiance. So if you are of mine, please stand, remove your hat if you're wearing one, like me, and place your hand over your heart and join in with Nana of JJS as she recites the Pledge of Allegiance. Chloe, put your paw over your heart.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
And, of course, I thank you for that wonderful rendition of the pledge, Nana. We all do appreciate it. If you would like your rendition of the pledge played here on the program, all you need to do is record yourself performing the pledge or reciting the pledge in your style. Take that audio file, video file, whatever kind of file it is, and, attach it to an email, send it off to me, send it to fans, FANS at AmericanPerspective.online. That's fans, FANS at AmericanPerspective.online. Chloe put her paw over her heart, by the way, just so you know. She's here in the studio with me. So there we go. Yes, I will be talking about Chloe quite a bit over the course of the time. All right, let's get to our sponsor. Headline sponsor tonight is the Institute on the Constitution. The Institute on the Constitution was established in 2004 as a 501c3 nonprofit with one singular mission, and that is to restore the constitutional republic through grassroots education. All courses and materials are developed using primary source documents and taught from the American view of law and government as defined in the Declaration of Independence in the following 3 key points. 1, there is a God. 2, our rights come from him. And 3, the purpose of civil government is to secure and protect our God-given rights. The IOTC offers the opportunity to educate ourselves in our most precious founding document, the Constitution of the United States. They also provide tools to educate your community and get involved with local government. Start by taking their free U.S. Constitution course and go from there. Use my affiliate link, iotc.americanperspective.online, to sign up. And while you are there, take a moment to look through their other course material and information. My affiliate link, once again, is iotc.americanperspective.online to get great content to learn about our historical founding and support the show in the process. That's iotc.americanperspective.online. Or if you just want to purchase this fabulous Saddleback leather-bound U.S. Constitution to support the show, go to constitution.americanperspective.online. This is a fantastic book. Take a look. It's an 1/8 inch of Saddleback leather wrapped around pages that are water and tear resistant. No cheap glue binding here. This is stitched all the way through the leather and the pages within. It's got a 100-year warranty against materials and manufacturing defects, such that if anything goes wrong with this, you can send it back to the manufacturer and they will either fix it or replace it for free. My rumblers all say it has sexy rounded corners. According to 3 Chevy, the amendments are actually in numerical order with fantastic Roman numerals. It is Chloe tested, Chloe approved, Buddy tested, Buddy approved, Billy tasted, Billy approved, and my youngest whiskey warrior has confirmed that the information contained within will help you to study for your civics badge in Scouts, as well as your civics exam. You might want to grab one today. Go to constitution.americanperspective.online, and according to Buddy, it repels Democrats upon contact. Go to constitution.americanperspective.online, get yours today, and while you are there, check out the rest of the information that the Institute on the Constitution puts out. It is all fantastic. I'm just telling you. Go and check them out, and I thank them for allowing me to be a brand affiliate. Chloe's smiling. She's liking that. See? You see that? She's smiling right there. She's like, hey, yeah, that's cool. All right. Okay, here we go. All right. So this is so far under the radar, so completely far under the radar, that I don't think that anybody really paid attention to it. Really, seriously, I don't think anybody did. But I'm going to give this person, this individual, his 15 minutes of fame. Well, maybe 15 seconds. But anyway, I'll come back to you, Chloe. I promise. I'll come back. Here's this guy, this representative whom nobody knows, right there. He apparently had, now keep in mind, he's in a hotly contested district, and in fact, right now he's got like several opponents in a primary, supposedly. I don't know what they mean by several. I mean, that could be 2. I don't know. Anyway, the point is that he apparently is at the end of his at the end of his career, because he's in a hotly contested district, I guess, and he's not doing very well. So he's desperate to get his name on the calendar. Well, he's putting his name on the calendar in a very idiotic way. Even his own people in his own party are like, man, you're an idiot. What are you doing with this? So, his effort to impeach Trump. So this is Representative Sri Thanadar. He's a 70-year-old Michigan Democrat, and he's drowning in primary challenges right now, according to this. He introduced 7 articles of impeachment against President Donald Trump late last month, citing the following things: sweeping abuse of power, flagrant violations of the Constitution, and acts of tyranny that undermine American democracy and threaten the rule of law. Now, on Tuesday, he implored his colleagues to support his articles of impeachment. And he was sitting there stressing about the point with a quote, "It's never the wrong time to stand up for our Constitution." Yeah. Apparently, he was pretty much told to shut the hell up because he was set to call up the resolution for floor consideration yesterday, and yeah, he backed down at the last moment. I think the Democrats finally looked at him and said, yeah, you're really not doing this. You need to just shut up and go away. Anyway, so there he goes. He got his 5 seconds or whatever kind of seconds of fame for doing this. And, obviously he's missing something because I don't recall any of the things that he pointed out as the high crimes or misdemeanors listing. Anyway, certainly isn't bribery or treason or any of that stuff. Whatever. Anyway, all right, I'm done. He got it. Let's bring Chloe back. Chloe's a better image to be looking at than that fool. But hey, he got his 5 minutes of fame, so now he can stand up at a microphone and say, I tried, sort of, to stand up. Yeah, anyway. In other news, another sad sack, tired out, run over, kind of person that, sort of like Joe Biden. Yeah, Hillary Clinton trotted herself out because she felt that it was time to come out and make some sort of a derogatory and disparaging statement about Trump on social media. And let's just say it didn't go over quite as well as she apparently was. I don't know if she was drunk, she wasn't thinking right, who the hell knows. Either that or her intern that she had, thought this would be just a fantastic idea to go ahead and do this. But she got nailed. And I'm not talking by Billy Bob. Oh my goodness. So she posted on X and she goes, no one gives someone a $400 million jet for free without expecting anything in return. And then she said, be serious. Well, there's a little bit of a problem. Clinton got a gift from Qatar. And this is part of the reason why I'm kind of arguing over this whole idea that, the president can't accept a gift on behalf of the U.S. government, because the emoluments clause, which everybody seems to want to all of a sudden go that they're constitutional scholars and they are thinking about this and they're like, oh yeah, the emoluments clause keeps people from getting gifts. Really? Let's see. In the past, the Clinton Foundation picked up a $1 million donation in 2011 by Qatari officials, according to Reuters back then. The foundation was forced to confirm, because they were going to try and hide it, they were forced to confirm that the gift from Qatar that it received it without informing the State Department. Oh, wait, without even informing Congress either. Wow, Clinton was Secretary of State. Yeah. And, by the way, subsequent emails that were published by WikiLeaks later revealed that the reason that they did that 1 million donation was because they wanted to meet Billy Bob. To hand him the check. Yeah. So anyway, according to that same report in Reuters, the Qatari government had donated up to $5 million to the foundation over the years, which were significant gifts to the former, and of course what many people thought at the time was the future president in Hillary. But it didn't stop with Qatar. So her taking gifts, and keep in mind, this is just during her tenure at the Obama's State Department, okay? Clinton lifted the foundation's self-imposed ban on accepting foreign government donations. Obviously, as she was ramping up for her presidency run in 2016, they collected, $14.5 million from Saudi Arabia, along with Kuwait, the United Arab Emirates, and Oman, all dropping between 1 and 5 million into the Clinton Foundation. Huh. So, yeah. Sure. And there were several people that went ahead and, like, called her out on the X forum. Further emails revealed that the King of Morocco, which again, in the Emoluments Clause, you're not supposed to accept anything from a king or foreign state entity or anything like that. Oh, yeah. The King of Morocco agreed to host a Clinton Global Initiative Summit and give $12 million if, and only if, Hillary attended the meeting in person in May of 2015. Something tells me that she was not only running for president at the time, but she was still, if I recall, the Secretary of State at that time. Yeah. So, World Strat President Jim Hansen wrote on X in response, "The Clinton Foundation is the gold, platinum, and diamond standard for buying and selling influence." You know, these Democrats, they just need to, like, shut the hell up. And all of their sycophantic followers, they need to do the exact same thing. This whole thing with the Qatari aircraft, first of all, it hasn't even been finalized yet, as far as I'm aware. Second of all, it's to the United States government. It has literally nothing to do with Trump himself. I mean, other than the fact that he happens to be in the office and they might be trying to, you know, extend goodwill or whatever. But anyway, what do you think about that, Chloe? Yeah, I don't think she's too convinced that Hillary Clinton is in the clear here either. She doesn't look it. She's like, that's a little suspect. Okay. So, the big news of the day. Told you about it last night. The Supreme Court of the United States listened to arguments with regards to the idea of universal injunctions. Now, it was tied to the idea of the birthright citizenship, or the case of the birthright citizenship. And to be honest with you, you know, and the justices kind of asked that question. They were like, well, wait a minute. We're here just to talk about the nationwide injunctions. We're not here to, like, discuss the merits of the actual case. And the Solicitor General essentially said, well, we believe that the merits of the case are good, and we're okay with that. We can just percolate that through the courts. But this whole idea of these injunctions, this is kind of suspect and in a bit of a bad scenario. Now, you recall last night I told you that many of the justices, maybe not all, but many of them have all sort of voiced skepticism for this idea of the universal blanket injunction. And therefore, I was expecting when I was listening to the questioning, now granted, I didn't hear everything because I was kind of in and out throughout the whole period where they were doing oral arguments, but I was sort of expecting to hear a little more derision from the justices. It actually sounded to me, from the in terms of an overall sense, that the idea of a universal injunction isn't necessarily completely abhorrent to many of the justices. That they feel, I got the feeling that they might be thinking, yeah, there's a possibility as to when these things could really come into play and really be effective. But the line of questioning seemed like it was more of a, how can we fence this in so that it's only utilized, rather than just saying, that's it, and never doing it again, but kind of fence it in and have it to where it's only utilized in extreme circumstances. And I think they were trying to figure that out. And, yeah, it just doesn't make any sense. Well, how do we get here with these things? Well, here's 16 of the most egregious of the injunctions. And I'm only going to read off their titles, okay? But the first one, obviously, is the courts trying to protect the illegal immigrants, the illegal aliens, and the terrorists, okay? We have Pasito versus Trump, which Judge Jamal Whitehead from Washington State, my state, no surprise there, he's basically saying that all of those thousands of foreigners have to be settled within the country. And then we have Community Legal Services in East Palo Alto versus HHS. And this one, let's see, was done by Judge Araceli Martinez Olguin. Let's see. We have JGG versus Trump, which JGG are the initials of the three primary people that were doing this. And this one was, of course, by Boasberg, our good old buddy James Boasberg. Then there's DVD versus DHS. That one was done by U.S. District Court Judge Brian E. Murphy. I'm starting to see, I'm not reading this off, but I'm starting to see a pattern here. Biden appointees, Obama appointees, things like that. Then we have the National TPS Alliance versus Noam. That would be Kristi Noam. And this one was, where's the judge in this one? Ah, yes, the Judge Edward Chen. Oh, another Obama appointee. Yeah, gee, I wonder why. Then we have a bunch of judges who think that the president isn't allowed to be the chief executive. These ones are Maryland versus U.S. Department of Agriculture. That one comes from Judge James Kelleher Brendar. Another Obama appointee. Gee, I wonder why. National Treasury Employees Union versus Trump. And this one is Judge Paul Friedman, who is a Clinton appointee. Starting to see a pattern here. What do you think, Chloe? You think you're getting a pattern? I know I'm getting a pattern. Anyway, NTEU versus Vout. And this one is from, where's the judge? Where's the judge? Come on. Where's the judge? There we go. Judge Amy Berman Jackson, who is an Obama appointee. And then we have New York versus Trump. And this one, this case has Judge Jeanette Vargas, who is a Biden appointee. Yep. New York versus Trump DRI. And this one is U.S. District Court John James McConnell, another Obama appointee. And then we have Casa Inc. versus Trump, New Jersey versus Trump, and Washington versus Trump, which is the actual case that's up there. And that one was done by U.S. District Court Judge Deborah Boardman, a Biden appointee. We have the AIDS Vaccine Advocacy Coalition versus the U.S. Department of State. That one was done by Judge Amir Ali, a Biden appointee. Then we have the other set of cases, which is the you are hereby ordered to mutilate children's genitals group, which was PFLAG versus Trump. Ooh, sorry, I'm going to take a second here because, buddy, I think Chloe and I would fit together because I like biscuits and gravy too, because Chloe apparently likes biscuits and gravy. So, is that true, Chloe? Yeah, that's true. All right. So back to the cases. PFLAG versus Trump. That was a order issued by Brendan Herson, Biden appointee. Then we have Schilling versus Trump. That was put out by Benjamin Settle, a George. Now this one's interesting. This is a George Bush appointee who did that one. And then we have Doe versus McHenry, Jones versus Trump, and Kingdom versus Trump. And that one was put out by Royce Lamberth, who was a appointee of Ronald Reagan. Then we also have the judges that believe the DEI indoctrination is essential. And so this one is NADOHE versus Trump, California versus the U.S. Department of Education. Those two got tied together, and U.S. District Court Judge Adam Abelson, who is a Biden appointee, oversaw that. So those are the 16 different cases that have all done. Yeah, well, it's because I'm looking at her picture over here. Anyway, that are all done. On the and have the universal injunctions. So there's a lot of cases, and there's more. Those are just 16 of the most egregious ones. So anyway, the Supreme Court went ahead and listened to them. Now, the Daily Signal put together a briefing, 5 takeaways from oral arguments on the universal injunction birthright citizenship case. And again, keep in mind, they kept questioning whether or not why they wouldn't be hearing the merits of the case. So I'm going to be honest with you. I think the Supreme Court is chomping at the bit to get a hold of this birthright citizenship case in reality. But that being said, Sawyer's arguments against universal injunctions. So Sauer noted that the courts have issued 40 universal injunctions against the federal government, including 35 from the same 5 judicial districts. This sounds like it is, shall we say, targeted in some way. But anyway, he argued that the injunctions prevent the percolation of novel and difficult legal questions throughout the normal legal process. He also argued that they encourage forum shopping, which, given the fact that 35 out of the 40 came from the same district. Yep. I get it. So anyway, he also further argued that they circumvent what's known as Rule 23, the process by which plaintiffs apply for class action. So the differences between the two cases, if you're an individual suing somebody, yeah, everything kind of stays within the case, and it's directed at you, and any kind of, injunctions are supposed to be directed at you getting relief. But the thing about it is that when you go to a class action, that means that you've got more than one or a few plaintiffs. That means that it could be an entire class of people, and therefore a universal injunction could be helping to prevent or provide relief for an entire class of people. But those are like a different sort of case, and that's kind of how they were discussing it and working through it. Again, I got the feeling that the Supreme Court was trying to figure out how to fence in this idea of universal injunctions without just flat out saying that they weren't going to do it. Now, the thing about it is, and I'm trying to grasp my head as to why these lawyers did not actually argue the fact that you have lower courts that were created by Congress giving directives to a constitutionally set up branch of government, that the power structure would prevent that from happening, because Congress can't necessarily tell the president how to do his job or anything, his or her job, same way that the president can't necessarily tell Congress how to do their jobs, nor can neither one of those two go and tell like the Supreme Court to do their job. Now, there are certain particular items as a part of the Constitution that each branch does have as a, let's call it a stick over the other one. For an example, Congress has the ability to impeach. That is an ability that is not given to anybody else and applies to both the Supreme Court and the presidency. At the same time, the president has the ability to veto something. So, and of course, the Supreme Court can rule things unconstitutional. So there are some checks and balances there, but they're very few. They're not given as a carte blanche. They have to be specific. And so anyway, I was kind of surprised that the lawyers didn't even touch that. They didn't even go to that level. They tried to argue it on a couple of other reasons. And of course they also picked on things like, the history of universal injunctions, that while they aren't, they aren't like a brand new thing, that the universal injunctions have been issued in the past. And I talked about this before on the program a while back, that the reality of the situation is that while they were attempted, they weren't really necessarily enforceable, and things ended up where the injunction ended up getting overturned anyway. So, I don't know. I'm confused. I'm confused with regards to, again, why the lawyers took these tacks, but they went ahead and did it. And so now they're kind of bouncing around the idea of this. And, but anyway, the point of, in terms of the history of this, sorry, I got a little lost there for a second. The point of all of this is that, historically speaking, the universal injunctions kind of exploded in the Obama era, the 2007 era. And so they were rare, very rare, to even be, put out back in, say, the 1960s. And this is what I told you before. So, again, kind of, and what's really novel about this is, again, they didn't even argue. Sauer basically said, John Sauer said that, well, while we agree that we could be arguing the merits, and I'm willing to go that way, but the point is that this isn't about the merits of the case, meaning the constitutionality. And in fact, the government really doesn't even question whether or not there is a question regarding the constitutionality of that. So of the birthright citizenship. But they are questioning the whole concept of these universal injunctions. So that's why I was kind of expecting somebody to say, hey, constitutionally speaking, the only person that could really rein in the other two is this body right here, this esteemed body right here. But anyway. So, yeah. And he, Sauer brought up the FDR's New Deal, which the FDR's New Deal had a slew of injunctions, but none of them were universal. They were all specific to the cases themselves. And that's why Sauer is basically saying, yeah, this is kind of the historical precedent for all of this, one of them. But anyway, there were two lawyers present for the plaintiffs, with John Sauer, of course, the defendants, with John Sauer being the plaintiff's attorney, the government's attorney. And in the second lawyer who got up to talk, her name is Kelsey Corcoran. Kelsey Corcoran. She started bringing up the whole 14th Amendment and its applicability and its original meaning. So she was attempting to try and argue the merits of the case in front of the Supreme Court justices. They weren't asked for that. And what a lot of people don't understand in terms of the Supreme Court of the United States, usually when you go and appear before the Supreme Court, you are granted a writ of certiorari. That writ of certiorari will have a question that the justices are supposed to answer. Well, in this particular case, the way that it came to the Supreme Court, that question wasn't even really defined. And so this is also the fact that the government brought it, and the government was basically saying, we're just looking for relief for the injunctions. We're not really looking to argue the merits of the case in front of you. Now, I believe it was Elena Kagan who basically told John Sauer, she's like, so she asked the question. She says, so what happens if you lose all of these injunctive cases that are already in the lower court system? What happens if you lose them all? Are you going to appeal? I mean, that's ultimately what she ended up kind of asking. And she goes, and she inputted her opinion, which essentially is, I would think that you do not want this to get to the Supreme Court. Sauer actually answered that under questioning of another one, which Sauer basically was like, well, we think it will eventually end up here, but we think that there is validity and merits to the case. And that they want, the government actually wants it to percolate through the lower courts first. It's kind of an interesting scenario and conundrum on this whole thing. But again, I go back to the point that this whole thing was about the universal injunctions. So, yeah. Anyway, they kind of went back and forth about different alternatives, different particular scenarios, whether or not a regular injunction could work just as easily as or just as well as a universal injunction. So again, I'm just kind of keeping letting you guys know and keeping an eye on the fact that it's going to be interesting to hear this when they finally come out with it, because again, like I said, unless they can figure out some sort of a backflipping way, which I don't put it past John Roberts to do this, to leave universal injunctions in place and basically say, yeah, well, it can only be used in these kinds of vague, specific circumstances that are, vaguely defined and everything else, because that's the way John Roberts operates. Right, Chloe? Yeah. Okay. So there we go. Chloe's not too convinced either. But anyway. So yeah, one other thing that the justices kind of pressured the lawyers on was how cases would move forward if they were to remove the universal injunctions. And they were saying that the nationwide blocks, could be beneficial in some cases. And this is part of the reason why I keep saying, or why I'm saying that I think that the Supreme Court is trying to figure out how to fence it in. But anyway, some of the justices expressed, this is according to the Epoch Times, some of the justices expressed concerns about how other people purportedly harmed by Trump's policy would get relief without a quote-unquote nationwide block. And this, of course, comes from Kagan and Sotomayor. They both indicated that they believe that Trump's order limiting birthright citizenship breached the 14th Amendment. So we already know where those two are going to go once it ends up in front of the Supreme Court. And I can tell you that Jackson is right there with them. But anyway, that a large number of people would be therefore harmed by Trump's order. And so, yeah. Anyway. So now it was kind of interesting, though, that Kagan told Sauer that if she were in her shoes, there was no way she would bring it to the Supreme Court. I already told you that. But after the intense questioning from Kagan on that, Gorsuch said that Kagan asked the questions better than he could. So both of them seem to be kind of thinking that without nationwide injunctions, those affected by the order would have to undergo a lengthy legal process in order to get relief again. So anyway, Chief Justice John Roberts seemed to actually take the opposite stance on that, saying that the Supreme Court has in the past intervened quickly in previous cases and was sort of suggesting that that same kind of speed could be used to provide quick relief in the future. So Roberts might actually be leaning toward the idea that universal injunctions are unconstitutional. While we already know where Kavanaugh and I think it's Kavanaugh, Alito, and Thomas, all three have questioned universal injunctions, as has Kagan in the past, but that didn't present itself today. And I think a lot of it had to deal with the subject matter of the material case, not necessarily the universal injunctions, but the material case that was underneath for that. So anyway, we're going to have to kind of see what happens with all of that. Well, there are some issues with regards to the state's case, in this case, against the Trump administration on the birthright citizenship order. The first is, of course, that the citizenship clause merely adopted what is considered to be the pre-Dred Scott common law rule that everyone born in the United States is automatically a citizen. I've made this kind of case here on this show before, and where it really falls out is the phrase "and subject to the jurisdiction thereof." The writers of the 14th Amendment were attempting to break that out, and this is shown in the congressional record with regards to birthright citizenship. And honestly, this is the 14th Amendment. The 13th and 14th Amendments were written as a congressional response to the Dred Scott decision, which essentially the Dred Scott decision, for those of you that don't know, pretty much basically said that no, children of slaves were not U.S. citizens. I don't know why they did that, but whatever. Anyway, the point being is that the Supreme Court at the time decided that no, they were not U.S. citizens, and so therefore they couldn't, be considered as such. And so Congress acted and wrote and passed the 13th and 14th Amendments for consideration by the states. And of course, as we know, they were eventually adopted. The thing about it is, though, is that the writer, the actual sponsor, and the person who wrote the 14th Amendment argued within the debate on whether or not to accept the 14th Amendment, because remember, in order for an amendment to get passed, 2/3 of Congress, and that means 2/3 of each house, have to approve it prior to it going to the states, where 3/4 of the states have to approve it before it becomes a part of the Constitution. So 2/3 of Congress had to agree with what was written as a part of the 14th Amendment. And what they do is they debate things back and forth. Well, the original sponsor, this was done in the Senate. The original sponsor basically stated as a part of this, basically stated, and his name was Howard, referring to what was the Civil Rights Act of 1866, which was, by the way, was also passed within that same time frame in an attempt to codify the clarification that the slaves and the children of slaves were actually U.S. citizens at that point. And the Civil Rights Act of 1866 was actual law at the time. The phrasing in the Civil Rights Act of 1866 was, all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States. So Congress was basically saying, yeah, according to us, this definition, there we go. They are not subject to any foreign power. Well, that would include things like foreigners. So the 14th Amendment drew from the Civil Rights Act of 1866 and that definition. And Lyman Trumbull, who is a Republican from Illinois and the primary drafter of the Act's citizenship clause, explained that one of Congress's main difficulties was trying to find language that would be adequate to sort of differentiate between foreigners and actual citizens of the United States. And so he basically recounted or talked about how they at first considered the qualifier that all persons born in the United States and owing allegiance thereto are hereby declared to be citizens. Congress rejected that phrasing, okay? Because according to them, it was, upon investigation, it was found that a sort of allegiance was due to the country from persons temporarily resident in it, whom we would have no right to make citizens. And that form would not answer. So in other words, what they were saying here is that, hey, you know, anyone who just comes here and like lives here for a little while, maybe they owe a little allegiance to the United States because they lived here for a bit. We don't want that in that. Congress said we don't want that to be a clarifier because that basically says that residency is not a requirement necessarily for this, to become this. So then what Congress settled on the final language of the Civil Rights Act. So all of that was debate about the Civil Rights Act. So the drafters and ratifiers of the 14th Amendment sought to cement this concept. And so what they did is they basically, and key members of Congress acknowledged that the reality throughout legislative history was the common law, which was, hey, if you live there, you're already there. Well, they basically went back and forth about it, but the guy, again, Howard, this is who I'm talking about, was essentially talking about it in the congressional record, and he literally said, this will not, meaning the 14th Amendment, will not, of course, include persons born in the United States who are foreigners, aliens, who belong to the families of ambassadors or foreign ministers accredited to the government of the United States, but will include everybody else. So he is literally saying, during the debates in Congress, that the 14th Amendment and the way that it's written does not include persons born in the United States who are foreigners. That would indicate the immigrants who have come here and not naturalized yet. Or the anchor babies that the Democrats keep saying that they are American citizens. Howard believed that they weren't constitutionalizing the common law rules. but that a rule that is consistent more with the Civil Rights Act focus on allegiance to foreign powers. That's where this is going to go. So this is going to be a key issue. So the error number 2 that the states are arguing has to deal with the executive branch long recognizing that they can't deny citizenship to children based on immigration or citizenship status of their parents. Well, this particular assertion only is true if history actually begins in the first half of the 20th century. So for decades following the ratification of the 14th Amendment, the federal government regularly articulated a view of the citizenship clause that is remarkably tied or connected to what Trump's order is. In 1885, Secretary of State Thomas Bayard, B-A-Y-A-R-D, instructed federal officials not to consider a U.S.-born man to be a U.S. citizen because his German parents were never permanent residents of the U.S. and returned with the child back to Germany. And this is where the Wong Kim Ark case kind of falls apart, because Wong Kim Ark, at the time, his parents were legal permanent residents of the United States. But the Emperor of China forbid any Chinese to be able to change citizenship to another country. And so, I mean, this is where the case got the idea, not the fact that Wong was born here of immigrant parents, but that they were already in a special legal status designated at the time of permanent residence. And so, according to the Supreme Court, under that case, they decided that, hey, because his parents are actually permanent residents, even though they can't become naturalized citizens, they are permanent residents. That means that he is actually a U.S. citizen. Now, you could make an argument either way on that, because they couldn't actually become naturalized. That would be the case. But that's the main case that everybody kind of points to, is the Wong Kim Ark one. All right. Yeah, and I just talked about that in terms of the Wong Kim Ark. So that's another error that the people bringing the case are saying. So the last error that the Daily Signal is calling out here, the president's order will leave many children deportable and stateless. Yeah. Anyway, it's not going to be left stateless. Virtually every nation, including the United States, recognizes some manner of citizenship by blood under which a child is automatically eligible for citizenship when one or both parents are citizens, even if that child is born abroad. In many countries, this hereditary citizenship is bestowed automatically. In some countries like India, the child is automatically eligible for citizenship, but only obtains it if the parents register the birth at an Indian diplomatic mission within 1 year. So there are other laws and things like that around the world that indicate that, yeah, not everybody believes that just because you're born on the soil, you automatically become a citizen. They actually, many of these people automatically do hereditary citizenship, just like we do. We assume that if you were born by at least one American parent, you are a U.S. citizen. Doesn't matter where in the world you were born, just if you were born of one American parent, which is kind of counterintuitive to the whole idea of a immigrant coming across the border, getting a green card or whatever, and having a baby on American soil automatically confers U.S. citizenship it's kind of opposite of the thought process in terms of a person born to U.S. parents. So you would think that that would confer a person born to a immigrant parent would be a confer hereditary citizenship from that immigrant to the child, which is essentially the whole argument of the case. So anyway, all of that is still forthcoming, folks, and that's going to take many, many years for it to just go all the way through. So anyway, well, in our final few minutes, Chloe, we're coming to the end of the show, sweetheart. I get it. She's upset. But anyway, Judge Dugan, or Duggan, I think it's Dugan. Yeah. Anyway, I think if it was 2 G's, it would be Duggan. But anyway, entitled Judge Duggan, or Dugan, is accused of obstruction for aiding an illegal alien. Her and her lawyer actually filed to a petition to have the case dismissed. And the reason why is because she's a judge and she has immunity. Wait, what? Wait, I don't seem to recall judges having immunity in things that they are not a part of. I'm kind of confused here, but anyway. So, the petition stated that it's not an ordinary case and that Dugan is no ordinary criminal defendant. Now, she's claiming, or the petition is claiming, that the prosecution of her was virtually unprecedented and entirely unconstitutional, violates the 10th Amendment. Wait, what? How does it violate the 10th Amendment and the fundamental principles of federalism? Immigration is completely within the hands of the federal government. It doesn't even go to the states. That's 100% in the hands of the federal government. But additionally, the petition claims that she is entitled to judicial immunity for her official acts. After entering the plea, though, she refused to answer questions about whether or not she had judicial immunity. I'm trying to recall. I don't recall. Maybe I missed it. But I don't seem to recall that within these 2 pages in here that it says that judges have immunity from laws. I mean, again, I told you about the one that's under Article 1, Section 9. Yeah, I kind of run it. No person treason, no person punishment, no judges shall extend also. Yeah, I don't see the word immunity in Article 3. Not to mention the fact that I would have to look at what Congress created, because she's actually a state judge, not a federal judge. So that's a bit of a problem, folks. She's a state judge. Yeah, I don't know. I just don't see in that Article 3, the setting it up, that there's immunity there. Yeah, I don't think so. I'd have to read the whole thing 100% for sure, but I didn't see the word immunity in there. So yeah, so she's, yeah. And by the way, this particular article in Woke Spy kind of points out that the alleged obstruction occurred outside of her official duty as a judge. She was not presiding over a case challenging the suspect's detention due to his immigration status. She actually had him in court for a different reason. And so anyway, yeah. Oh, all right. Before we go, I have a programming note. Tomorrow, no show. I unfortunately have a work thing that's going to prevent me from being able to broadcast on time. So tomorrow there is no show. I will pick you up Saturday, 6 p.m. Pacific, 9 p.m. Eastern time, right here on American Perspective. And do me a favor, if you haven't already, head on over to rumble.com, get yourself an account. It is free. And when you are signed up and signed in, okay, you can, search up the American Perspective channel and hit that follow button to get notified every time I go live. Chloe and I say thank you for joining tonight. Thank you for joining tonight. And like I said, we will see you Saturday, 6 p.m. Pacific, 9 p.m. Eastern time, right here on American Perspective. Have a great rest of your weekend. And from Chloe and myself, good night, everybody.